Well, good evening, everybody, and welcome to the fourth in this year's series of Readers' Lectures. And I'm delighted this evening to welcome Professor Cheryl Thomas to speak this evening on giving judges a voice in democracies. Professor Thomas is the Professor of Judicial Studies at University College London Faculty of Law and has advised a large number of bodies on the judiciary, juries, and the criminal justice system. She's done research and provided information to those bodies on the system and appointment for training of judges, and she's probably added more than anyone else to our understanding of juries and the way that they operate and how they need to be informed and helped in their role in the criminal justice system. She is also, of course, the Inner Temple's first Dean of Education, a role which was created to highlight the importance that the Inn attaches to education throughout all of its functions, and we're delighted that she is assisting us, particularly with our education and training building underway. I'm sure that she'll play a great role in that. But if I can welcome her this evening, Professor Cheryl Thomas.
Thank you, Master Reader, and thank you to everyone who's joining us online this evening. Before I begin, I want to briefly explain what will happen in tonight's lecture. I'm going to be sharing my screen with all of you at various points in tonight's talk. What this means is there may be a second or two delay each time I move between speaking directly to you, as I am now, and sharing my screen with you. But I think after 8 months of us all having to work out how to communicate virtually, we're all becoming a bit more familiar with how this works. And I'm sure we're all aware that sometimes there may be glitches. I'm doing this because I think we've also learned that watching a static screen with just one person speaking at you is not the most enjoyable way to spend 30 minutes or more. So I hope it all runs smoothly this evening. In this talk on giving judges a voice in democracies, I'm going to cover three things. I'm going to explore the mechanisms British judges can use to express their views in public and how these have changed over the years. I will also share with you some key findings from my research with judges in the UK, which explores judges' attitudes and experiences and tries to give them a voice. And I will consider some of the challenges in a democracy of giving judges a voice like this outside of their court judgments. And at the end, I'd be happy to answer your questions. So in a democracy, the judiciary is the third branch of government. It's equal in importance to the legislature and the executive. And today in the UK, it's hard to think of a single important social issue that judges aren't at some point asked to pass judgment on. So I'm going to share my screen with you now for the first time, I hope. Right, I'm hoping that everyone is able to see that now. If you're not, please do let me know. Right, so the extent to which we as a society ask judges what we as a society ask judges to do, I think is very well summed up by US Judge Shirley Hufstedler, who was the first female appellate judge in the United States. To illustrate her point in this jurisdiction, for example, in just the last few years, the courts here have been asked to determine whether medical treatment should be withheld from terminally ill infants against their parents' wishes, whether private landlords must check the immigration status of their tenants, who can legally be classified as a mother, whether terminally ill people should be allowed to determine when and how their life ends, and of course, whether the government can do something like trigger Article 50 to leave the EU without getting Parliament's consent, or can lawfully prorogue Parliament for 5 weeks. This in turn means that judges are subject to a greater level of public scrutiny, political debate, and media attention than ever before. But unlike the other two branches of government, in a democracy, judges historically have not had a voice. Until a few years ago, judges in the United Kingdom had never been asked what their views were on their relationship with government, the public, and the media, or asked what role they feel they play in society as judges, or how they think society views judges. That changed in 2014, when the first UK Judicial Attitude Survey was run, exploring the attitudes and experiences of judges in England and Wales, Scotland, and Northern Ireland. So, bearing with me again. It's the first and only study of the views of judges in all the UK jurisdictions. And it's a longitudinal study, which means it's run on a recurring basis. The UK Judicial Attitude Survey was run for a second time in 2016 and most recently again this year in 2020. And this allows us to understand how judges' views may be changing over time. Tonight in this lecture, I'm going to consider the importance of providing this type of voice to judges in a democracy, as well as the challenges that can result when judges are given such a voice. Before exploring some of the findings of the Judicial Attitude Survey, I want to look with you at how historically we've approached the idea of judges having a public voice. Of course, judges have a voice through their legal judgments, but judgments very rarely tell us much about how judges view their relationship with the other branches of government, the public and the media, or what their views are about being a judge and their role in society. So should judges have any other voice in democratic society? Well, traditionally in this jurisdiction, the judiciary has relied on others to speak for and speak up for judges. Most prominently, this reliance has been placed on the Lord Chancellor, who has an obligation in law to defend the independence of the judiciary. In taking the oath of office, the Lord Chancellor swears to defend the independence of the judiciary. Share my screen with you again. And the Lord Chancellor and other government ministers also have specific statutory duties under the Constitutional Reform Act to respect, protect, and defend members of the judiciary carrying out their judicial functions. But events in recent years have raised questions about whether the judiciary can always rely on the Lord Chancellor to fulfill this obligation. And I'm sure most of you will be well aware, the most notable example of this was the lack of a fulsome defense of the judiciary by the Lord Chancellor following the press attacks on judges in the 2016 ruling over the need to obtain parliamentary consent to trigger Article 50. In this context, it's useful to remember how the judicial voice has evolved in England and Wales and what role different Lord Chancellors have played in this evolution. During the last century, judges were bound by the so-called Kilmuir rules about when judges should and should not speak outside the courtroom. These were, in fact, not formally developed judicial rules of conduct. They were the personal views of the then Lord Chancellor, Lord Kilmuir, who in 1955, in a letter to the Director General of the BBC, said the overriding consideration is the importance of keeping the judiciary in this country insulated from the controversies of the day. So long as a judge keeps silent, his reputation for wisdom and impartiality remains unassailable. In the United States, there's traditionally been quite a different view of this, and Jerome Frank, one of America's leading legal realists, warned that it is a mistake to try and maintain public esteem for our courts through ignorance. And after over 30 years, the Kilmuir rules were publicly abandoned in 1987 by Lord Mackay at his first press conference when he became Lord Chancellor. More recently, Lord Neuberger made it clear that judges should have some voice outside of their judgments. In a speech in 2012, when he was Master of the Rolls, Lord Neuberger endorsed a judicial voice when he said that judges, with their wisdom and experience, should be able to comment extrajudicially on a wide range of issues. So judges can and do speak publicly now. Many senior judges give speeches on legal themes. One only has to look at the websites of the Judiciary of England and Wales and the UK Supreme Court to see the large number of speeches by senior judges in recent years on a range of legal issues. All of this is permissible because now there is, in principle, no objection to members of the judiciary speaking about legal matters that are not controversial via lectures, conferences, or seminars organized by professional bodies or by academic institutions. Senior judges now also routinely give evidence to parliamentary committees. The Lord Chief Justice, Lord Burnett, spoke just last week to the House of Commons Justice Select Committee. And judicial participation in select committees is usually confined to commenting on the operation of the courts, the independence of the judiciary, or aspects of the administration of justice. This type of judicial voice is permissible because it is thought to contribute to public understanding and confidence in the judiciary. So, for example, last week, Lord Burnett, when he was speaking to the Justice Select Committee here, spoke about the advantages and disadvantages of using remote hearings, how the courts are coping with social distancing, and the backlog of cases in the courts. But there are restrictions on what judges can and do say publicly. They do not have the same right to a public voice as you and I. And there are now judicial conduct rules that regulate judges' public comments, whether in person or online. And they also regulate their political activities. These rules make it clear that judges have to accept that their judicial office exposes them to considerable scrutiny and puts constraints on their behavior which other people do not experience. By long-standing convention, judges cannot comment publicly on the merits of individual cases, and they must also refrain from answering public criticism of any judgment. But in addition to that, judges are also not supposed to comment on government policies, proposed legislation, or public appointments. And these conventions have been designed to promote the dignity of the judicial office, the finality of judgments, and the independence of the judiciary from other branches of government. There's also a statutory prohibition under the Constitutional Reform Act on judges being involved in any political activity or having ties with any political party. So this means not attending political gatherings, political fundraising events, demonstrations, or contributing to political parties. And judges also have to take into account their family's political activities. So where a close member of a judge's family is politically active, the judge needs to bear in mind the possibility that this might raise concern about the judge's own impartiality and detachment from the political process. And when it comes to social networking, blogging, the use of platforms such as Twitter, while this is not strictly prohibited from judges, if judges do communicate online in this way, they must not identify themselves as members of the judiciary. They must also avoid expressing opinions which could damage public confidence in their own impartiality or the impartiality of the judiciary in general if it became known that the person communicating in this way were a judge. This applies to blogs which claim to be anonymous, so this would rule out any secret judge blog along the lines of the secret barrister. And the failure to adhere to these rules could result in disciplinary action for any judge. So given these restrictions on judges having a voice in society, how then can we understand what it's really like to be a judge, what their attitudes are to being a judge, their working lives, the relationship they have between the public, the government, and the media? In many jurisdictions, the answer is simply, we cannot know. And that was certainly the case here until 2014. But since 2014, judges in all the UK jurisdictions have been given some voice through the UK Judicial Attitude Survey. And I'm going to explore this in the findings of the survey with you now in some detail. But first of all, just to let you know, the survey explores judges' views on a wide range of issues. This includes their working lives, their motivation to be a judge, their view of the role of the judge in society, the concerns they have in their working lives as judges, and also how this might affect their willingness to continue in their judicial roles or their willingness to encourage others to become judges. And I think it's worth remembering that Lord Kilmuir believes something like this was a very dangerous thing to do. That if people knew more about judges, that would jeopardize the standing of the judiciary in society. But two Lord Chief Justices in England and Wales, along with the Lord Chief Justice of Northern Ireland and two Lord Presidents in Scotland, have had faith in their judges and allowed the UK Judicial Attitude Survey to be run 3 times over the last 7 years. Lord Thomas, when he was Lord Chief Justice, initiated the Judicial Attitude Survey in 2014 for all salaried judges in England and Wales, and agreed to run it again in 2016. The current Lord Chief Justice, Lord Burnett, agreed to continue the Judicial Attitude Survey this year, even in the middle of a pandemic. The UCL Judicial Institute conducts the UK Judicial Attitude Survey on behalf of the different judiciaries. The Judicial Institute is an independent academic body. It's not paid to conduct the Judicial Attitude Survey, and the results of the survey are made publicly available to anyone in all of these jurisdictions. The UK Judicial Attitude Survey is now the longest running survey of a judiciary anywhere in the world. And this enables the experiences and views of judges to be mapped over time and to explore how judges' voices may change. We've lived through some turbulent times for the judiciary since 2014, and I believe there's a need for independent, objective research giving judges a voice. And the UK Judicial Attitude Survey is quite a clear voice. Almost all judges have taken part in this study. The first year it was run, 90% of judges took part, and this rose to 98% in 2016 and 99% in 2020. So I'd like to share some of the findings of the survey with you now, and hopefully to illustrate the value of hearing this judicial voice. So let me start with I'd like to start with a press headline about judicial salaries. Okay, so this probably will not come as too much of a surprise as a headline from the Daily Mail. And this followed the first of the judicial attitude surveys in which judges were asked about their working conditions and their remuneration. Because judges are restricted in what they can say publicly, it can be difficult for the public to interpret media stories like this. The Judicial Attitude Survey, I think, has enabled judges to speak at least indirectly by providing an important truth and context to this easy clickbait headline from the Daily Mail. Would like to share this with you now as one of the findings of the Judicial Attitude Survey. So as you can see, we can see an important reality to this story. A majority of all salaried judges in England and Wales take a pay cut to be a salaried judge. Some 27% of them take a very substantial reduction in income when they decide to become a judge. It's also important to understand this in the context of the fact that becoming a salaried judge also means accepting the no return to practice rule in England and Wales. That means that once you become a salaried judge, you cannot return to your legal practice when you leave the bench, even if you decide to leave early. No other profession I'm aware of in England and Wales operates under this restriction. It is also not the common practice in other common law judiciaries. So why do judges become judges? I'm going to share some more of the findings of the Judicial Attitude Survey for judges in England and Wales that gives some insight into how judges see themselves, their role in society, and the relationship with other political institutions. So first, what motivates someone to become a judge? Hopefully you're all seeing this here now. As you can see, the main factors that motivate members of the legal profession to become judges in England and Wales is the chance to contribute to justice being done, the challenge of the work, the commitment to public service, and the intellectual satisfaction of the job. Next, what do judges think of their role in society? Almost every single judge felt that she or he is providing an important public service to society. And this view is pervasive amongst judges in all judicial posts in both the courts and tribunals. But how do judges think the public views them? As you can see, over 2/3 of judges feel that members of the judiciary are respected less now than they were 5 years ago. Just under 1/3 feel that the levels of public respect for judges have stayed the same, and only a very small minority feel that judges are respected more than they were 5 years ago. So we explored this a bit more by exploring judges' perceptions of their relationship to a range of groups. And here you can see who judges think values them. I hope that's all clear to everyone, but I'll tell you that the results are that judges feel most valued by their immediate colleagues, by court staff that they work with, the legal profession that they work with, and the parties who appear before them in cases. It is interesting, I think, to note that over 2/3 of judges do feel valued by the public, but almost no judges feel valued by the media, and that's even less so in terms of the proportion of judges who feel valued by the government. Given this, we also explored how concerned judges are by recent conflicts with the government and attacks by the media on judges. So as you can see, both of those feature amongst those issues of greatest concern to judges, but these sit alongside strong concerns over staff and budget reductions, the increase in litigants in person, and the loss of experienced judges in the judiciary. So are there any real risks in giving judges a voice in democracies? Well, first of all, I think there is an inevitable risk of misunderstanding when judges' views are revealed. And we saw that with some of the press conference coverage of the first Judicial Attitude Survey, which focused very heavily on judges' views about their salary. But I think we also need to recognize that there's likely to be some public confusion about which judges can speak publicly and which cannot. The judicial conduct rules I outlined earlier apply primarily to salary judges. Fee-paid part-time judges, of which there are very many at almost all levels of the judiciary, are not under any general legal prohibition on political activity, although they are expected to refrain from any political activity which would conflict with their judicial office or be seen to compromise their impartiality. There's also no prohibition on political activity and public debate by retired judges, provided they're no longer sitting. However, they should take care to avoid any activity which could tarnish the reputation of the judiciary or the perception of its independence. The reality is that the retirement age leaves many senior judges with new public roles, and some of our most senior judges in retirement now play an important legislative role in the House of Lords, including now retired UK Supreme Court justices and retired members of the Court of Appeal, such as former Lord Chief Justices Lord Judge and Lord Thomas, and former Vice President of the Queen's Bench Division, Baroness Hallett. Some retired UK Supreme Court justices have also turned to political commentating. They've published their memoirs and diaries and commented on public issues from their new academic positions. But I think we may want to consider how well the public understands the distinction between a fee-paid judge and a salaried judge, or whether it's always clear that a retired judge who continues to be referred to as a judge in the press is not speaking in a judicial capacity. And finally, let me turn to the issue of US-style confirmation hearings for judges. This raises the question, should judges be forced to have a voice and speak publicly before they are actually appointed? Following the UK Supreme Court's decision in the Miller-Cherry case, the current Prime Minister has suggested that this is a real possibility. Share my screen with you again. In an interview in the days following the Supreme Court's judgment, Prime Minister Johnson said that if judges are to pronounce on political questions in this way, then there is at least an argument that there should be some form of accountability, and he said the lessons of America are relevant. The then Attorney General Geoffrey Cox told the House of Lords following that there may very well need to be parliamentary scrutiny of judicial appointments, even though he said he was not enthusiastic about this. If there is any serious intention in this country to learn lessons about judicial appointments from the United States, what needs to be clearly understood is the difference between US Supreme Court appointments and any other judicial appointments anywhere else. US Supreme Court appointments are what is called Article 3 appointments. This refers to the article in the US Constitution that governs the appointments, tenure, and salary of federal judges. Article 3 judges hold their offices during good behavior, which means in practice they are lifetime appointments. It's also important to note that there is no minimum age of appointment for federal judges in the US. So the US practice of life tenure and no minimum age or experience requirement for Article 3 judges is highly unusual and not replicated anywhere else in the common law world. This long tenure is what provides the primary justification for the role of elected officials in the process of nomination, which is controlled by the President, and confirmation, which is controlled by the Senate, of US Supreme Court justices. In contrast to what happens in the United States, for UK Supreme Court justices, there is a 15-year minimum legal experience qualification and a legally binding retirement age that now forces all UK Supreme Court justices to retire at 80. And I'm going to share my screen with you again. This means that US Supreme Court justices that UK Supreme Court justices actually serve for very short periods of time. More than half of all UK Supreme Court justices who have now retired only served for 3 years or less. In comparison, the average tenure for US Supreme Court justices is 17 years. Suggestions that Parliament should be involved in UK Supreme Court judicial appointments are not justified on the same grounds as they are in the US. They also create the possibility of lengthy parliamentary hearings that are very disproportionate to the justice's time in office. So why does it matter that we give judges a voice in our democracy? In practical terms, it matters for the future of the judiciary. For the law students and the young practitioners attending this lecture tonight, the future judiciary will come from your ranks, and it's important that you have a real insight into the actual working lives of serving judges. But it's also important for society as a whole that some demystification of the judiciary occurs by hearing from judges themselves. Contrary to what Lord Kilmuir thought, giving judges a voice through the Judicial Attitude Survey has not caused the sky to fall in. as Jack Knight, a leading American scholar of the judiciary, explained, understanding judges is a necessary feature of any adequate explanation of the evolution of law in a democratic society. Today in the UK, judges are increasingly subject to a greater level of public scrutiny and political discussion than ever before. This has come in large part as a result of the growing deferral to judges to address deeply controversial political and social issues, often ones that Parliament and government are unable or unwilling to address. This brings judges increasingly into the public, political and media eye, but as we explored tonight, independent judges will always necessarily have a limited public voice beyond their judgments. And given the rules that restrict judges' role in society, it's perhaps not surprising that judges lack any real built-in source of public support. Unlike politicians, judges who are not elected do not have a natural public constituency. Judicial independence requires that a judge be seen to be independent of the sources of power or influence in society. This means that giving judges a voice through independent analysis of their attitudes and experiences, as we do in the UK Judicial Attitude Survey, is more necessary now than ever. Thank you, Master Reader, and I'd be very happy to answer any questions.
Thank you very much for that, Professor Thomas, and not only for giving us the lecture this evening, but also for conducting the survey and devising it and making sure that judges do have a voice, albeit indirectly. So I'd now like to take some questions. If anybody has a question, if you press the raise hand button, then we'll come to you. I'm not seeing any raised hands at present. Oh yes, Noah Gifford.
Thank you. Professor, thank you for that. I have two questions, if I may. Firstly, after your summarising of thoughts on judges post-retirement, what do you think of Lord Sumption's attitudes, which have spread around the media, on the coronavirus regulations, and if you think that that is undermining the position of the government regulations as a whole, and maybe influencing and undermining the judiciary's separation of power doctrine in supporting the government on political matters, as it were. And secondly, I know this is a different matter to what you spoke on, but I'm interested. I've read your report on Our Jury's Fair from 2010, I think. I'm just wondering whether you think the fade factor in juries is a correct assumption for the judiciary to make. Thank you.
Okay.
Yes, we've got two questions there. I think it's what's called a bog-off.
I think so. Well, I think the main answer I'm going to give is in relation to your question about Lord Sumption and his political commentary in relation to COVID-19. I'm not going to express a view about the content of those views, but it goes to what I was talking about. I think there is some reason for concern if the public does not understand that a retired judge is not speaking on behalf of the judiciary. And I think there's probably very little public understanding of the fact that serving judges are under the types of restrictions that they are under about speaking publicly, and that once retired, those restrictions pretty much disappear. So it's very usual when the media is discussing or has an interview with a retired judge the word judiciary and judge will appear in those stories. And I think it's a little bit of a reason for concern if there is any misunderstanding about whether a retired judge is speaking in a personal capacity, or if there's any confusion that it might be a reflection of judicial views. So I hope that answers that question. As for our jury's fair, this is slightly off message, that one, in relation to what we're talking about today. What I would say is doing research with juries is giving a voice to juries, and there was a lot of very similar concern in the past, very much along the Kilmuir rules, is let's not ask juries about anything because it's dangerous to hear what they have to say and we might not like what we find out. That has not proved to be the case in this jurisdiction. All the research that we've done over many years now with actual juries at court has told a very positive story about juries' ability to try the cases based on evidence and law, and the lack of bias in juries in this jurisdiction. As for the fade factor, I'm not sure how many people watching this evening will know about the fade factor, but the idea there is about media reporting of cases that are tried by a jury. And the legal principle is the further away the media reports are from the actual trial, the more likely they are to fade from jurors' memories and therefore not have an impact in their decision making. You rightly pointed to the study, Our Jury's Fair from 2010, in which we actually looked at that issue in detail with actual serving juries on a wide range of cases, including those that had very substantial media coverage before and during the trial. And it confirmed the existence of the fade factor, that actually jurors have very little recollection of media coverage of their cases that occur before the trial.
Thank you. I'm going to ask Claire Nevin. Thank you.
Thank you, Professor. My question is about the Public Administration and Constitutional Affairs Committee's call for evidence ending today, with a view to potentially setting up the Constitution, Democracy and Rights Commission. And it's widely reported that perhaps Lord Sumption will be chairing this commission eventually. Patrick O'Connor QC alluded to that possibility in his submission to this call for evidence. Now, I noticed that you didn't want to mention or comment on any content that Lord Sumption might have spoken about, and his views on judicial overreach and fundamental rights are known. But I'm not going to ask you about that. I want to ask you if his potential role as chair, in light of what people know of his views on rights and potential judicial overreach, would be appropriate as a retired Supreme Court judge, in light of the impact that this can have on our democracy going forward and people's fundamental rights.
Well, you know, retired judges do serve really important function in this jurisdiction. They assist with inquiries and heading commissions and so on. So I don't think that there's any inherent reason to think that a retired judge of Lord Sumption's position should not be involved in an inquiry. You know, I guess the main thing to say is that any inquiry like this or commission, you know, needs to have a good range of views that are being heard and being expressed and taken into consideration. A chair has obviously some power and some function within that, but it's not a single, you know, judge only inquiry into this. So it will be interesting to see who else would be involved in that commission. And, you know, one would hope that there are a good range of views expressed, and that there will be a way for judges to have a voice.
Thank you. Ian McCabe.
Thank you very much indeed for your lecture, Professor. In order to maintain the public's perception of the impartiality of judges, should judges publish their membership of organizations? In particular, I'm thinking of there was a proposal that judges should publish whether they were members of the Order of Freemasons, for example, but that didn't follow through. I was wondering if you could comment on that.
Well, it's interesting. You know, different jurisdictions deal with the issue of private memberships for judges in different ways. There's been perhaps some more laissez-faire attitude to it here than in other jurisdictions. So, for instance, you know, the issue has arisen a number of times here about whether private capacity be members of a private members club that, for instance, excludes women. In this jurisdiction, that is permissible. But in the United States, for instance, that would be a breach of the Judicial Code of Conduct. So while an individual can belong to a private members club that excludes women, it's thought, for instance, amongst federal judges, that is not permissible for a judge who is required to apply the law equitably to all individuals. So, you know, there's just a different approach taken here. My personal view, I suppose, is that as a judge, I think you have to be extremely careful, as the judicial conduct rules imply, about your associations. So we'll see if there's any change to the judicial conduct rules in that regard. But yeah, as I said, it's a bit more of a laissez-faire approach here.
And specifically in relation to Freemasonry?
Well, you know, this was an issue quite a while ago, probably 15, 20 years ago, and there were requirements to declare amongst a wide range of individuals involved in the administration of justice, the police, and so on. My understanding is that has changed now because it was thought no longer to be such a significant issue. But I think it goes to a whole range of issues about, it's not, you know, the Freemason issue was very, very high on the agenda probably 20 years ago. It is less so now, but there are all sorts of private groups. And I think, as I tried to set out for you, the Judicial Code of Conduct does make it clear that judges do have to be very careful and think about the implications of it becoming known, their associations with different groups. Clear restrictions to do with politics, but you know, some of the boundaries get quite blurred these days between politics and private groups.
Thank you. I'm going to ask Belize Harrison next, because I think you were trying to ask a question earlier, but you couldn't raise the hand function.
Hi, yes, thank you. First of all, apologies that I'm not on video. I'm not allowed to have my webcam on in the office. So my question is a rather topical one around the situation in the US at the moment. As we all know, Donald Trump has threatened legal challenges around the conduct of voting, and he also recently appointed his administration recently appointed Amy Coney Barrett to the Supreme Court. If these legal challenges in relation to the election are heard by the Supreme Court, in order to protect the integrity and the independence of the Supreme Court decision on the matter, should Amy Coney Barrett, I mean, in your opinions, obviously it's a subject point, recuse herself from the hearings? And then the follow-up question is, if she doesn't, is there any procedure available to make her? So is it just a voluntary position for her to recuse herself, or can she be made to do so?
So, you know, I think it's probably not for me to say whether she should recuse herself. That recusal is a judicial decision. I think that, of course, there would be calls for her to recuse herself, but there is nothing legally, formally, that would require her to. She has been nominated and she's been appointed through due process. As you know, set out in American law, she is a validly appointed US Supreme Court justice. You know, the issue would be down to her about whether she felt that there was a particular reason why she would need to recuse herself in a particular case. I think it's also highly unlikely that we're going to see any of the voting the election challenges going to the Supreme Court, but it would very much depend upon the exact nature of the case that came to the court, and whether she had expressed any views on that, or it related to anything she might have said in her confirmation hearing.
Thank you. Rosamond Bennett.
Hi, thank you very much for your insightful talk and the survey that you shared. I was wondering, what do you think, it may be a personal opinion, but if you could share with us what you think the UK could learn, the UK jurisdiction, might I add, could learn from the US jurisdiction and vice versa. Is there a possibility, the follow-up question is there a possibility for real change in your view and in your experience? Thank you.
Yeah, thank you for your question. Could I just come back with the question to make sure I understand? In what respect are you asking me what I think the judiciaries here can learn from the US? Do you mean?
The simple area of length of service, for instance. You mentioned 3 years as opposed to 17 years for US judges.
Yeah, so what I was trying to set out there is something that's often really, people are not aware of, the reasons behind the nature of the voice given to judges in the US prior to their appointment to a federal post. And can I just say, there are Senate hearings for federal judges who are not US Supreme Court judges. So we tend to only focus in on the very high profile appointment of US Supreme Court judges. I was trying to set out in the difference between the nature of service on the Supreme Court in this jurisdiction compared to the US, and what it is about the really, really unique aspect of American Supreme Court justices' tenure that doesn't apply in really any other common law country. So they can be appointed as young. There is no lower age limit. There's no experience requirement. And because they serve constitutionally during good behavior, and the possibility of impeaching a US Supreme Court judge is virtually non-existent. That means that most US Supreme Court judges will serve for a very long time. If 17 years is the average, you can imagine that there are some who serve for much longer than that. And it was very interesting. I did a study of how long the UK Supreme Court justices have been serving. It's hard to talk about an average length because the UK Supreme Court hasn't been operating for that long, but I thought it was very interesting if you look at every single UK Supreme Court justice who has now retired, the fact that half of them have served for 3 years or less. It just gives you a bit of perspective on the idea of holding appointment hearings for UK Supreme Court justices. The relative long-term impact of their role on the court compared to the US is quite stark, I think. So I hope that answers. And your second question, could you just remind me?
If you saw possibilities existing for real change or not.
Real change where?
In the system, the UK system.
And sorry to keep asking you to elaborate, but the possibilities for real change in what respect?
Well, in terms of the average length of service, for instance.
Oh, I see. Well, yes, as the court goes on, there is a decision in appointments about the age of the individual who's being appointed. So the extent to which that's taken into consideration in appointments is a very interesting question. Something we don't know because that's not necessarily revealed. Although it may be, we certainly have the example of not on the UK Supreme Court, but in the most recent appointment of our Lord Chief Justice, it was made very specific that the person appointed had to be able to serve for 5 years or more. And that would eliminate someone who was coming up to retirement age before that 5-year period.
Thank you.
I think we've got time for a couple more questions. Richard Hine.
Hello, yes, thank you. I just wanted to ask, given that, as you said, the next generation of judges will be kind of coming from our peers, and there'll be people who've grown up having social media accounts and using social media, do you think it's either necessary or inevitable that the expectations and rules about judges having previously expressed views publicly will need to change to reflect that? So I can understand people, closing their social media accounts once they're appointed judges, but once, all of their previous accounts are on the internet, they're out there for everyone to see forever.
It's a really good question. Well, first of all, when someone's appointed, they don't have to disavow any view they expressed before they were appointed. But I think what you raise is a really interesting issue about the longevity of people's previous views being expressed on social media. That's very different, isn't it, than the opportunities prior to social media. So I think the next generation of people being appointed judges or entering into legal practice and so on, you're having to make judgments now about what you want to be seen and retained about you online. It's a really, really difficult situation to be in. And I'm sure as time goes on, there is going to have to be some thought about this in terms of whether that affects someone's prospects for appointment. But I think you raise a really good issue. It's something people need to be thinking about now. But at the moment, there's nothing that inherently would say that your involvement on social media in the past would necessarily prohibit you from a judicial appointment.
Thank you. And Natalie Walker.
Thank you, Master Reader. And apologies for me being a little bit late. I had a few technical difficulties. My question for you, Professor, is if the Prime Minister gets his way of having US-style confirmation hearings, do you think that that could lead to the politicization of the judiciary as it has due to the advent of C-SPAN in America and the televised confirmation hearings?
Well, what I would say first of all is I think the Prime Minister has been a little bit opaque about whether he really is saying he wants US style appointment hearings. He simply said the lessons from America may have something to teach us. So that's dangling that out there. I think it's also important to note that just the existence of C-SPAN and things like that is not what has made American US Supreme Court appointments political. They have always been political, and it is in the nature of the role that the US Supreme Court plays in the American political system that is fundamentally different than the role the UK Supreme Court plays in the UK political system, that has made US Supreme Court justices and their selection a more openly political process. So, the difference, just the bare difference between the two political systems is that, in the parliamentary system we have, the judges do not have the final say on the interpretation. Well, they have the final say on the interpretation of the law, but that interpretation can be changed by a simple act of Parliament. In the US, that is not the case. The US Supreme Court judges have the final say on the interpretation of the US Constitution, and that's what gives them their political significance.
Thank you. And our final question for this evening is Grace Etheridge.
Thank you, and thank you, Professor. I was just wondering if you could expand on any practical recommendations that maybe emerged out of the report. For example, ways to embed the judicial function in the public imagination, or at least in like educational establishments or in the media?
Yeah, that's a really good question too. First of all, I think it might be helpful to know that the surveys that we do, the judicial attitude surveys that we run for the three different judiciaries in the UK, are done to assist the leadership of those judiciaries in better understanding their own judges and how they can assist in the working lives of judges. So you've raised a much wider issue that's an important one about public awareness and education about the judiciary. And that's a responsibility in this jurisdiction of the Lord Chief Justice. And certainly there's been quite a bit done under the current Lord Chief Justice to expand judges' reach into schools and education with much younger people about what a judge's life is really like, what they do, and so on. But on a somewhat related point, your point about recommendations or that come out of the survey and how it can assist the judiciary. Something I didn't talk about. There's much more in these judicial attitude surveys than the specific issues I covered with you this evening. But for instance, in 2016, we asked for the first time, or judges were asked for the first time, about any concerns that they might have about their personal security, whether that was in court, out of court, or on social media. And I think that was the first time that any of the judiciaries were really aware of the extent of judges' concern about their own personal security in any of those three settings. And that's been, I think, really important in helping the judicial leadership to try and address those concerns with judges. So I think there are some really positive, helpful things that can come out of the survey. The surveys also have been tracking judges' experience with technology in court and remote hearings and all of those things, and all of that will feed into how the court process will adapt and change, for all of you in the future.
Well, thank you very much indeed. I think that we will stop there. I know there's still one or two people who want to ask questions, but I know that you've come to the end of your time that you've made available to us. And again, I'd like to thank you very much, Professor Thomas, on behalf of all of us, for both a very interesting talk and also for answering some questions, which again raised a lot of issues, which I'm sure were very interesting to all of the students. So thank you once again. I'm sure everybody would like to thank you.
Yeah. And thank you everyone for joining this evening. If anyone has any particular issue they really want to raise with me, you can find my email address on the UCL Law Faculty website, and I'm very happy to hear from you.
Thank you.